If you're looking to put together your estate plan and you're wanting to make sure that you're taking care of someone who has special needs, like a disability, or who is ever contemplating needing government assistance, this video is for you. The care of any special needs loved one, like a child or another family member, is a difficult, burdensome process. If you're putting together your estate plan and one of your intended beneficiaries is special needs, it's vital that you understand the implications of your estate planning and put something together right away. This video is intended to give you information about what methods are available for basic estate planning and preparing for how your property will be divided and how you can care for your beneficiaries, especially if you have someone who has special needs that you're trying to care for after you're gone. If you're already taking care of someone with special needs, I don't need to tell you how complicated the rules are regarding qualifications for government assistance, guardianships, conservatorships, accountings. Your life is very stressful already. Unfortunately, some of those complications extend to your estate planning options. Now, the biggest bull in the room for anyone with special needs is eligibility for government assistance. The government does provide some benefits for those with special needs. However, those are all needs-based, which means if someone has too much property, they no longer need the government assistance. Where that plays in for estate planning is that if someone who is on needs-based government assistance receives an inheritance, well, they've got money and they no longer need government assistance. The government's very happy to look at that inheritance and say, great, you got money, you don't need us anymore, you're disqualified. This isn't the end of the world. There are what are called supplemental or special needs trusts, which are designed to protect the eligibility of a special needs person to preserve their eligibility for government assistance. There's a few techniques available for you to start considering to bring to your estate planning attorney. Some approach this and say, it's easier for me to just disinherit my special needs beneficiary. In some cases, that may be advisable, but I think they're rare given that there are alternatives. Some people would look at it and say, I'll just give the inheritance I intend for the special needs person and give it to a sibling, their brother or sister or caretaker. That has some major drawbacks to it because if you give it to someone else, if that person dies, becomes incapacitated, needs government assistance themselves, or is going through a lawsuit like a divorce or any sort of other creditor issues, they've lost their ability to use the inheritance you intended for your special needs beneficiary, and now they have to spend it on their creditors. So let's say you give it to the brother, who is going to be the caretaker for your special needs child. If they go through a divorce, the divorce court may say, well, this now is marital property. It wasn't set up in a trust or any strings attached. It just belongs to the brother. Therefore, it's marital property. We're going to divide it in half, and half goes to the spouse. It's all subject to that divorce. And that means you can accidentally disinherit your special needs child, or whoever you're trying to care of, that it's vital that we ensure that their funds are set aside to take care of them. So I don't recommend giving the money to any third parties because of that. Now, you can set up either within a will or within a trust what's called a supplemental needs trust. If we set up a will for you and the will says, here's the amount I have set aside for my special needs child, either a percent of the estate or the full estate or a cash amount, you just say whatever is set aside for this child because their special needs is going to be held in a supplemental needs trust. The third option that's available to you when you're taking care of a special needs child is to create something called a supplemental or special needs trust. This trust is designed to hold all of the proceeds of your intended inheritance for this child, but the terms of the trust itself say that the funds and anything in the trust itself cannot be used in any way that would deem that beneficiary ineligible for their government assistance. And in fact, any distributions being made out of the trust need to supplement what the government provides. That's why it's called a supplemental needs trust. A supplemental needs trust then can hold the inheritance and be used for the benefit of that child, subject to a lot of rules and conditions. However, it allows for an inheritance to be held for their benefit to supplement what the government provides in a way that does not disqualify that beneficiary from their benefits. Knowing that that's available, that tends to be a go-to tool for estate planning when we set it up. Now, this can be done either in a will or a trust. A will can say whatever share I have for this person whose special needs will be held according to this supplemental needs trust language. You can also put it in a trust itself. The difference between the two is a will has to go through probate in order for its terms to be set up, in order for the funds to get into that supplemental needs trust. Probate itself is expensive, and the fact that we're creating a trust within a will increases the cost quite a bit because there's a set of rules about how trusts are set up within wills and how that trust has to open a separate case heading and file accountings year by year as long as it exists. That's all avoidable if you're wanting to avoid probate. You can create what's called a revocable trust, and its very purpose is to avoid probate. Putting all of your assets into this trust, it can say the same things, that we have a division. Maybe your other kids are taken care of if you have them, or if you have someone, if you want everything going to this special needs person, we put all of their funds into a supplemental needs trust for their benefit. And the supplemental needs trust is just contained within your trust, hard written into your estate planning documents. We alternatively could create a distinct supplemental needs trust if other people are going to be giving money to or for the benefit of this special needs person. Sometimes it's a good idea to just have a document that's there that says anyone who wants to contribute to their livelihood, but we don't want to get them kicked off of government assistance, then we have a vehicle. We have a place where you can write those checks or who can hold those funds. It's called a standalone supplemental needs trust. Those are some of the techniques available to ensure that whatever funds that we wish to get to or for the benefit of your special needs person is not going to kick them off of their benefits. So all of this is not intended to be legal advice. Please do not go out and start crafting your own estate plans, especially if you're dealing with special needs beneficiaries. The laws surrounding their eligibility is incredibly complicated. There are many, many pitfalls. This is an area I'm very passionate about. You fall into a category where you have a truly heightened need to put together a well-crafted plan by a very qualified attorney. And so this is an area where I love helping families out because I know that you are stressed beyond the max. You carry loads on a day-to-day basis that the rest of us don't ever have to dream of. And so you're already carrying enough stress, caring for this disabled person day to day, keeping them up to their appointments, getting them qualified for whatever benefits are there, filling out forms and applications. That's a lot. It's also a huge stressor to even be thinking about what's going to happen after you're gone. And so a well-structured estate plan is a vital step for you. It is truly vital in your situation. You need to put something in writing to prevent this cataclysm from happening. If you don't have a estate plan in order, or if you inadvertently in any way get money to go to the special needs person, you can kick them off of their benefits. And the default rules of Kansas do not protect people with special needs. By not having a will or a trust in place, by default, if this is your child that we're caring for, they are your heir at law. So by default, they're entitled to receive a portion of your inheritance. And so even by default, it's something that would cause them to be ineligible upon your death. So you need to take proactive steps to put your plan together. You have options of either doing this through a will or a trust. Reach out to our office right away. We look forward to working with you and seeing if we can put something in place that's going to give you that peace of mind.